All right. This webinar concerns with the constitutional right to protest under the Constitution of Pakistan, and also about the limits of that right, and what is the extent of the restrictions is there. I'll start by describing or defining the constitutional legal framework concerning the right to protest. And I'll also discuss or mention some of the jurisprudence. And then I think Samam and Hamza, I think they will be discussing the limits of the governmental power in terms of the subject matter, and I think Brothers will be shedding some light on the international best practices. So, so I'll only take 5 minutes maximum, and then you guys can take over. The right to protest. Uh, Basically, there is no explicit right to protest in the Constitution of Pakistan. There is no such word as a right to protest. In fact, the right to protest it's a composite right, which means that it consists of various different fundamental rights that combine to form the right to protest. It was clarified or held in a judgment titled Suo Motu Case number 7 of 2017. From the Supreme Court of Pakistan. It was a judgment by Qazi Faiz Isa in the very famous Faizabad Dharna or Faizabad sit-in case, right, where of course that the TLP or Tehreek-e-Labbaik Party of Pakistan, they froze the capital of Pakistan, and they blocked the main road that led in to the city, and they blocked the traffic, and they froze the public life in the city. So it was an important issue of public. It was an important public issue that dealt with fundamental rights of the citizens of that city, and so the Supreme Court mentioned that the right to protest has its roots in the democratic nature of the Constitution of Pakistan and its governmental system, right? And it is made of the freedom of assembly, freedom of association, freedom of movement, and freedom of speech. Article 15, 16, 17, and 19 of the Constitution of Pakistan, right? So, but this right, like many other fundamental rights, is not an absolute right. It is subject to reasonable restrictions, right? Now, what makes restrictions reasonable, right? So there is a very generic term often used in legislations or the Constitution, which is the public interest. So the right is subject to public interest or public morality or terms like that. However, the courts have gone on to further define in a structural manner or in a more certain manner such restrictions, right? So in a very recent judgment by Lahore High Court, where I think Justice Jawad Hassan, he discussed the reasonable restrictions on the right to protest or any other fundamental right. He stated that the restriction is reasonable when it is proportionate, right? So a fundamental right, when someone exercises his fundamental right but also violates the rights of others. For example, if someone is blocking a road, a public road, right, and protesting on anything, right, now he is exercising his right to protest. How he's exercising his right to assembly. However, he is also violating his fellow citizens' right to free movement. In this case, the law can intervene and limit and place restrictions on his right to protest. Now, these restrictions can be termed as reasonable, right? So I'll briefly go through these judgments, and then I can, hand over the forum to sum up. Suo motu case number 7, the constitution does not specifically stipulates right to protest. However, democracy recognizes such right, and it was through democratic means that Pakistan was achieved. The right to protest is also implied in the right to assemble peacefully, in the right to form associations or unions, in the right to form or to be a member of a political party, in the right to freedom of speech and expression. The court also quoted an earlier judgment of Abdul Wali Khan case, where it was held that the right to of assembly is a very important right for preservation of democratic political system, yet it cannot be denied that no state can tolerate utterances of action which they threaten to overthrow the government established by law in that state by unlawful or constitutional means. The right of assembly, the freedom of association, and freedom of speech cannot be exercised by infringing the fundamental rights of others. As I mentioned, the reasonable restrictions, right? So the right is not absolute; it is subject to reasonable restrictions, right? So every citizen in a political party has the right to assemble and protest, provided such assembly and protest is peaceful and complies with law imposing reasonable restrictions in the interest of public order. The right to assemble and protest is circumscribed only to the extent that it infringes on the fundamental rights of others, including the right to free movement, to hold and enjoy property. Okay, this judgment of 2016 by Supreme Court of Pakistan discusses when a restriction is reasonable. It states that the reasonableness of any restriction on the right to freedom of expression, it should essentially be kept in mind as to whether in purporting to exercise of freedom of expression, one was infringing upon the right of freedom of expression of others, and also violating the right to live a nuisance-free life, and as to whether one is right to time and space was being violated. It was inevitable to maintain equilibrium by placing reasonable restrictions on the freedom of expression and the maintenance of public order. Unless the restriction struck proper balance between the freedom of expression guaranteed by Article 19 of the Constitution and the social control permitted thereby, it must be held to lack the attribute of reasonableness. So essentially, any restriction is reasonable when it strikes a proper balance with the individual's right with the right of the community at large, right? So yeah, so this was a brief, description of the constitutional framework. Now I think Samam, you can take over.
Right, so when it comes to the right to protest, the very first case we've got is, as Abdullah discussed, the 2017 suo motu jurisdiction by the Supreme Court of Pakistan. And interestingly, while the Constitution does not prescribe a specific right to protest, this judgment did. And whilst essentially laying out the right to protest, the one restriction or the grounds of potential restrictions it did lay out was a right being circumscribed only to the extent that it infringes on the fundamental rights of others. So this is our starting point when it comes to looking at the legality or limits of the right to protest. So interestingly, in this case, the Tehreek-e-Labbaik Pakistan's protest, I believe it was, essentially choking the Faizabad interchange, which was the instrumental jugular for any transport. So essentially, it infringed on the right to movement and all the other resulting rights. And the court essentially held that any peaceful protest which interfered with rights such as the right to movement or the right to hold or enjoy property, it could be restricted by the government. So the Faizabad criteria is essentially where we start when it comes at looking at the legality of any right to protest. Now, if we go beyond that, we've got the specific constitutional articles, as Abdullah said. We've got the rights to assembly, the right to association, the right to freedom of speech. So beyond the Faizabad suo motu jurisdiction, we'll have to look at these articles specifically and how they've been interpreted by the judiciary to come at any conclusion as to where we lie when it comes to the legality therein. So First of all, we've got the right to assembly. Essentially, the right to assembly, there are three requirements. Would entitle any citizen to the first two. These are more easily ascertainable, but when it comes to public order, this is where things get more interesting. So the Constitution essentially says that reasonable restrictions can be imposed on the right to assembly as long as they're imposed by law and in the interest of the public order. So in 2019, the Islamabad High Court did interestingly state that the state could only intervene from stopping people or citizens exercising their right to protest in extraordinary cases. But in the very same case, it also said subject to reasonable conditions and that the state had to consider several factors. Now, one of these is public order. And whilst public order hasn't been specifically defined by either the Constitution or by judicial precedent, the Lahore High Court has in Abdul Hamid Qadri versus Lahore, and then in Shukruddin versus governments to public tranquility. So as you'll see, judicial precedent has defined public order for the purposes of the right to assembly very broadly. So as long as the state sees fit that the particular cases or the facts of a protest fall within this broad definition, it is entitled to intervene and act to curb that specific the right. When it comes to reasonable, again, this is also very interesting in the way that it has been defined. So any restriction has to be reasonable in its operation. Again, the courts haven't really given us a definition for this. Instead, they've gone for a case-by-case scenario, since this is a subjective question, and any single circumstance of reasonableness will differ from case to case. So in the Pakistan's Broadcaster Association versus Bremer case, the Supreme Court did admit that it was not easy to define reasonableness, and that it wasn't advisable either to apply a standard definition for all universal. And in this, it essentially laid down that the state could look at the nature of the right that was being infringed, how long it was being infringed for, and to what extent. So you've got the definitions and the interpretation of the Constitution. Essentially, that is the state's discretion. But other than that, and a very interesting limit which the Constitution provides is that any restriction has to be imposed by law. So the state can't essentially go ahead and say, oh, we feel like what you're doing in this protest is a danger to this and this, and so we choose to clamp down on your protest. No, the state can't do that. So there has to be a specific law which is reasonably defined and which essentially restricts the right. So the mainstays in this, we've got the Pakistan Penal Code, and then we've got the CRPC, the Police Order 2002, and then the Maintenance of Public Order Ordinance. Now, all of these allow for the restriction of assembly. So the PPC defines what unlawful assembly is. It goes into what intent or what objects comprise unlawful assembly. Now, as long as you're within any protest is meets that definition, the state is entitled to act and move against a specific protest or a specific assembly. But if the state finds itself going outside of those and seen as one singular right to protest. But if we look at the right to freedom of speech as well, Article 19, once again, it relies on the same definitions of public order or reasonableness. But then, very interestingly, It also looks into how threatening to overthrow a lawful government is an offense, and how this may be declared unlawful and proceeded against by a magistrate if it's seen that this could cause obstruction, annoyance, or injury, or risk of obstruction, as well as an affray. So this is section 144 of the CRPC. Another very interesting.
Yeah,
Yep.
just you can wrap this up by answering this question. How would you apply this legal framework or the limits of the governmental power in terms of the right to protest to the PTI's protest or long march on 25th of May? Was were the actions of the government legal in terms of placing all those barriers or impediments in the path of the political party?
Right. So first of all, essentially, to look at the context in which the lives for the cause. Now, essentially, if you look at this, it doesn't, at least on the face of it, seem to be a lawful exercise of peaceful assembly. And if this was strictly speaking the case, then the government would have been entitled to act legally to move against such measures. But again, that isn't exactly what happened. So the purpose of the march was to protest against a purportedly foreign regime being installed. But Khan's demands were not unconstitutional or unlawful. He wasn't threatening to topple the regime explicitly. What he did ask for was the dissolution of assemblies and fresh elections. Now, all of that was within the constitutional framework. To that end, his demands were lawful. But now, where things get interesting is, and as noted in the Faizabad case, is the march or the protest, the procession was held at D-Chowk, which is inside the red zone. Now, in the Faizabad case, the Supreme Court was very explicit about the fact that prior permission had to be undertaken and how designated locations had to be used to actually exercise the right to assembly. Now, the D-Chowk is interestingly inside the red zone and is an area of specific national interest and security. So to that end, the government could have been, actually would have been, so it would have been entitled to act against the very fact that the protest was held within this venue, especially in light of a 2016 judgment by the Islamabad High Court, which held that you had to look at designated venues to exercise your right to assembly. And in this case, it would have been the Democracy Park and Speech Corner. So not even going into allegations of violence and of the protest not being peaceful, I think this factor in itself would have entitled the government to move against the march. But then again, reports of violence and of pelting of stones, that would have taken away any ambit of peaceful protest, the constitutional protection from the protesters themselves.
Okay, thank you. Okay, I think we can move on to the international team. I think further, so Hamza, who will go first?
I'll go ahead. So with what's already been discussed, I think we should look at in light of the international standards. So the right to protest, as Abdullah, you already discussed, again, is not really mentioned. It's more of a peaceful assembly. But historically, if you look at it, protests have often inspired, positive social change and advancement of human rights, and they continue to help define and protect civil space in all parts of the world. So in regards to international law, right to freedom of association and peaceful assembly are recognized in various treaties, including the ICCPR or the OHCHR or the ECHR and even the UDHR. Together, these rights constitute the right to protest. if we High Commission for Human Rights has mandate to promote and protect the right to peaceful assembly. Now, in regards to what's already been mentioned, such as Article 16, and the freedom of assembly, you won't see a right to protest. Again, it's even the OHCHR even looks at monitoring, reporting, and management of protests or warning preventions of violations. And this is further backed with the ECHR Article 11, the freedom of assembly and association, again, similar to Article 16, the right of individuals to gather with other people and make their collective voice heard is fundamental to properly functioning democracy. If you look at an example, which is in August 2010, the EDL, which is the English Defense League, planned a protest in Bradford. A counter demonstration by Unite Against Fascism was also planned that same day. Some local people wanted the protest banned, but West Yorkshire police actually had a duty to protect the protest unless there was clear evidence that violence would occur. Now, similarly to, as already discussed by Samam, I think the ambit of violence is a clear indication of why the Long March would not fall under international standards, because aside from the red zone and the location of the protest, the main concern is for a peaceful assembly and the aspect of proportionality in a sense. Yeah, because during that the protest, in a sense, there was violence, and that violence was not proportionate to the fundamental rights of the individuals, and therefore on an international basis, you can see this also be an issue with the ICCPR from Articles 18 to 22, which again, similar to the constitutional framework of Pakistan, the right to freedom of thought, conscience, and religion, the right to hold opinion without interference, propaganda of war shall be prohibited by law. Article 21, the right of peaceful assembly, right to freedom and association with others. Again, these are all international frameworks that would have been violated in that sense. But in regards to the limits of the government powers, in particular, Article 21 of the ICCPR, which imposes not only a negative duty on the government to refrain from, let's say, undue interference in demonstration, but also a positive duty to protect and fulfill the exercise of the right to peaceful assembly. So in short, to facilitate people's ability to exercise the right, by the same token, international law recognizes only peaceful assembly. However, you need to take into account Article 4 of the ICCPR, which again, in some sense, allows for certain circumstances for state parties to derogate from their responsibilities under the covenant, such as during times of public emergencies. So in this, you mentioned, certain restrictions of public interest. Again, I don't think it was a time of public emergency for Article 4 to be invoked for a state to, derogate from that aspect of peaceful assembly and, violate those fundamental rights. And further, those violence and counter demonstrations do not justify the denial of right of others to demonstrate. So essentially, if the government is involved, the government also remains responsible for securing the peacefulness of a protest, while always refraining from the excessive use of force. For this reason, any dispersal of an assembly, if a government wants the assembly dispersed, should not occur where only an identifiable individual, Khan, for instance, or a subset of the larger group engages in violence.
Okay.
For this, I'd like to continue.
Yeah. Thank you. For this, I have a question for you to consider in your presentation. How does the international law or the international best practices in various jurisdictions define proportionality in terms of reasonable restrictions on the right to protest? What is proportionality?
Well, before I begin, I started looking at different jurisdictions as you also started with looking at the proportionality and reasonable test. However, what I think is more important with the analysis is to start with really the international treaties that basically set the standards, because the national laws more or less follow the same wording. So that's why and I will just share my document just to guide you, and therefore I have some definitions and examples of what proportionality is, or what restrictions are basically justified. So I have firstly looked at the European Court of Human Rights, because that's the one that gives a really good guideline on the freedom of assembly and association. And it's on Article 11. I've looked at basically the negative and positive obligations which are imposed on the states. And the negative obligation from that sense means that the public authorities must not prevent, hinder, or restrict peaceful assembly, except to the extent allowed by Article 11.2, which are the justified restrictions, so to say, and must not arbitrarily interfere with the right to freedom of association. And the positive obligation on any state is that in certain circumstances, the authorities are under a duty to take reasonable steps to protect those who want to exercise their right to peaceful assembly. So they do have to do something. I have many details on the thing, but I don't want to lose from the time. It said that, as I said, Article 11.2 of this convention provides that the right to freedom of peaceful assembly and freedom of association can be restricted in certain ways, as also Smam noted, as it was in the Constitution of Pakistan. And the restrictions must be lawful and in pursuit of a legitimate aim, such as national security, public safety, the prevention of disorder or crime, or the protection of the rights and freedom of others, and is necessary in a democratic society. So basically 3 requirements. And the restriction must also be proportionate, meaning that the measures taken are the least restrictive necessary to achieve the legitimate aim. And then I've looked at the restrictions on the right of peaceful assembly based on Article 21 of the ICCPR, and Pakistan has ratified that convention. So I thought the wording and just the interpretation of that provision would be more pertaining to what we are looking for. Yes, so again, the restrictions must be necessary in a democratic society, they must be proportionate, and they must be based on democracy, the rule of law, political pluralism, and respecting the human rights. And they must be proportionate, and how it's proportionate has been interpreted by the experts in this general comment, basically, that it requires a value assessment weighing the nature and detrimental impact of the interference on the exercise of the right against the resultant benefit to one of the grounds for interfering. If the detriment outweighs the benefit, the restriction is disproportionate and thus not permissible. And then there are the legitimate grounds that have been enlisted, and they include the interest of national security, public safety, public order, the protection of public health or morals, and the protection of the rights and freedom of others. I might just read for the national security and public order if you want, and the rights and freedom of others, because these are the ones that we mentioned. So for the national security, basically that's a legitimate grant, and if it's necessary to preserve any state's capacity to protect the existence of the nation, its territorial integrity, or political independence against a credible threat or use of force. So where the very reason that national security has deteriorated is the suppression of human rights, this cannot be used to justify further actions, including on the rights of peaceful assembly. And when it comes to public order, it has been defined or referred to as the sum of the rules that ensure the proper functioning of society, or the set of fundamental principles on which society is founded, which also entails respect for human rights, including the right of peaceful assembly. And it has been stated that state parties should not rely on a vague definition of public order to justify overbought restrictions on the right of peaceful assemblies, because it has been stated that peaceful assemblies can in some cases be inherently or deliberately disruptive, and require a significant degree of toleration. And when it comes to protection of the rights and freedom of others, it has been stated that assemblies are a legitimate use of public and other spaces, and since they may entail by their very nature a certain level of disruption to the ordinary life, such disruptions must be accommodated unless they impose a disproportionate burden, in which case the authorities must be able to provide detailed justification for any restrictions. And in connection to that, to all of that, it was summed up that the rules applicable to the freedom of expression should be likewise followed when dealing with any expressive elements of the right to assembly. Yes?
Yes, go on.
Oh, I thought you asked something. And restrictions on peaceful assemblies must does not be used explicitly or implicitly to stifle expression of political opposition to a government, challenges to authority, including calls for democratic changes of government, the constitution or the political system, or the pursuit of self-determination. They should not be used to prohibit insults to the honor and reputation of officials or state organs. Again, in accordance with the Article for Freedom of Expression, peaceful assemblies may not be used for propaganda for war or for advocacy of national, racial, or religious hatred. I think that is all guessable. For freedom of expression, which is in relation to right to assembly, freedom of assembly, there were some case law from the European Court of Human Rights, actually two that are somehow interesting, is that in one of them, the court found that a protest performance in the cathedral consisted in a mixture of verbal and non-verbal expression and amounted to a form of artistic and political expression, carrying within the ambit of Article 10 of the Convention. So when we are dealing with the right to freedom of assembly, we can all the time look those rights at the same time, because as we mentioned previously, the right to protest is a composite right. Yes, and I have also found a background paper which is still being drafted by the expert, but I think it's a really interesting guideline when it comes to shedding more light into the aspects of right to protest. And there, as Mom also mentioned, and I think you, Abdullah, the term protest is also not defined under international law. The right to protest, therefore, does not exist under international law, but it is encompassed in the other fundamental rights that we mentioned. Then there were some suggestions proposed to what protest means, or right to protest means, but I haven't noted down all the detail, but they said that they can refer to various forms, purposes, various audiences, places, and so on. Well, this report basically presents all the best practices that the special rapporteur is of the opinion that could and should be applied by other state parties. And I've just made a summary out of the ones that caught my attention, so to say. And for example, when it comes to right to hold and to participate in a peaceful assembly, the special rapporteur said that in any state, basically the police or the relevant authority shall be obliged to facilitate the peaceful assemblies in any event, and that has been the case, for example, in Armenia. The best practice in this case, it has been stated that the exercise of fundamental freedom should not be subject to previous authorization by the authorities, meaning that a notification procedure for holding a protest, for example, is enough, according to the special rapporteur, and requesting a further authorization is unnecessary, and indeed it infringes further on the fundamental rights. And it stated that in Armenia, Austria, Canada, and Finland, Indonesia, and many more countries are actually applying a notification procedure. And for example, under the Spanish court, you don't even have to request any authorization for that. Then it holds as best practice legislation that, for example, allowing the holding of spontaneous assemblies should be also exempted from prior notification, which gives more freedom for the people to basically hold their protests spontaneously. And that has been the case in Armenia, Estonia, Germany, the Republic of Moldova, and Slovenia. The right to be protected from undue interference. The rapporteur holds also that as a good practice, the establishment in Estonia, for example, of a police rapid response unit, which aims at protecting peaceful demonstrators against attacks by counter demonstrators, and it's trained in how to separate the main counter demonstrators from the peaceful demonstrators. And basically, the laws governing freedom of assembly that both avoid blanket time and location prohibitions and provide for the possibility of other less intrusive restrictions are what the special rapporteur basically recommends and calls for all the states to impose. And he also reiterates that any restrictions, again, imposed must be necessary and proportionate. Reference to the proportionality test is found in legislation governing peaceful assemblies, including in New Zealand and Switzerland, that I still have to check because I couldn't access the national law, the exact one, but I will follow up on that. There were again some recommendations when it comes to what a country can do in order to build and strengthen the human rights capacity of administrative and law enforcement officials. And lastly, I've just had two developments per country, which is one is Malaysia, where the Court of Appeal finally ruled it unconstitutional to criminalize spontaneous public assemblies in breach of the 10-day notice required. And this has been marked as a landmark judgment in Malaysia. And basically being applauded by the international community, so to say, because it has been a country where the right to protest couldn't be exercised as freely or as it should be. And there was one case of the Ramila Maidan incident in India, which again was a landmark judgment, although not a recent one. And it concerned demonstrating dharnas. The court held that people in a democracy have the right to speak out against the government's decisions and inappropriate acts, as well as to express their views on any issue of national concern. And therefore, the government must respect and promote the exercise of such rights. And I think that's it. And there are two other documents that I'm still analyzing. And then
that's
I am going to focus
plenty.
on
Plenty.
per country, because to be honest, when it comes to the right to protest, even in the countries that are considered to be the most democratic, I just hold my mind when I, read the measures that have been taken, because the constitution says one, and what has been applied in practice, especially recently, they have enacted so many new laws when it comes to measures for the police. They can do things that, are not really human things. So
Yeah.
I thought, okay, these are not really good practices, although the constitution is pretty democratic. So that's why, in order not to lose time, I take the kind of back way analysis. But I will continue to look at case law per country. If I find something that, has been stated as a development, as in Malaysia, for example, then I think it would be, more reasonable to include it, other than as a bad practice because it doesn't work for us.
Yeah, okay. Thank you, Furthers, for this comprehensive description of international best practices. Okay, just yeah. So I think we can move on to conclusions, yeah. Before doing that, I have to mention a judgment by I think Justice Jawad Hassan of the Lahore High Court. 2022 Lahore 148. So he was discussing the phrase reasonable restrictions. So he referred to the Advanced Law Lexicon 4th edition, that the phrase reasonable restrictions connotes the limitation imposed on a person in enjoyment of the right should not be arbitrary or of an excessive nature beyond what is required in the interest of the public. The word reasonable implies intelligent care and deliberation. That is the choice of a course which reasons dictates, right? So if you see the last paragraph, or para 27, with that is, it is evident that the word reasonable implies intelligent care and deliberation. That is the choice of a course which reasons dictates. In other words, the concept of reasonableness is nothing but that of harmonizing individual rights and collective interests. So basically, the courts in Pakistan have not defined the limitations upon the fundamental rights, or particularly in this case the freedom of assembly or association or freedom of speech. What they have mentioned here is that whenever there are restrictions on any of these fundamental rights, those restrictions must be reasonable. What is reasonable, right? Reasonableness is when we balance the individual right with the collective right of the community, right? So, and the response, that restrictions must be proportionate to the end that is sought to be achieved, right? And etc. But I think we can't really have a certain or one definition of what reasonable restriction is, or what the public order means, or what the public interest means. Although courts have referred to the situation where the public interest is threatened when an exercise of a right threatens the rights of other citizens, right? In that case, we can say that, okay, this is an issue that threatens public order or public interest. Or when exercise of a right threatens the integrity or sovereignty of a state, then we can say, okay, this is a situation where public order, public interest is threatened, right? So yeah, so vagueness is there, but of course, I think this situation of reasonable restrictions or imposing reasonable restrictions in any case has to dealt on a case-by-case basis. But discretion, the governmental discretion or the legal power to impose restrictions should be defined narrowly. They cannot be broadly defined, because broad definitions lead to abuse of power and violations of fundamental rights. So I think this will be enough. Do you guys want to add anything? Samam, Hamza, do you guys want to anything in terms of what should be there in Pakistan's legal framework?
You know, as already mentioned with the international standards, I think when it comes to this, you read out para 27, this intelligent care, you know, it almost as if it's trying to say, you know, like tread carefully in what you do. So in regards to the recent events or the long march or whatever so far we've discussed, I think it's important to note the aspect of proportionality is what I interpret comes from intelligent care in all of this. So I think again, having a broad definition, agreed, it does lead to power. So
Yeah.
that's
Yes. As I think Furthest mentioned some of the requirements of when someone
yes.
is thinking about imposing restrictions, they must think whether the restrictions are legal, you know, they are necessary in a democratic society to preserve the democratic order, or whether they are proportionate to the ends that are sought. Maybe these three things can be thought about or you know, considered when we are about to, you know, place some restrictions on anyone's fundamental rights, or in this case, right to protest. So thank you guys for this very insightful session. And I am sure we will be, you know, holding these sessions after every, you know, 7, 8 to 10 days. So yeah,
Mhm.
so I'll see you in the next one. Thank you.
Thank you.
Bye.
Take care.